Your grandmother was born in Italy and was an Italian citizen, but her children, your grandfather or your mother, were born before 1948, and for decades, the Italian state refused to recognize Italian citizenship for her descendants. This is called a 1948 case, and there is a solution. Let us explain from the beginning exactly what 1948 cases are and why they exist. Italian law number 555 of 1912, the foundational citizenship law of the era, allowed only men to transmit Italian citizenship to their children. If the father was Italian, the child was Italian. If the mother was Italian but the father was a foreign national, the child was not recognized as an Italian citizen. This meant that thousands of Italian women who emigrated to the United States, Canada, and other countries married foreign nationals and had children, but their children were not recognized as Italian citizens, regardless of how strong their Italian family identity was. January 1st, 1948 is the turning point. From that date, with the entry into force of the Italian Constitution, the principle of gender equality was enshrined in law. From that moment, Italian women could transmit their citizenship on equal terms with men. But what happens to the children who were born before January 1st, 1948 to an Italian mother? That is precisely the problem we call a 1948 case. The remedy for this historical injustice came in 2009. With landmark ruling number 4466 of 2009, the Italian Court of Cassation held that the exclusion of children of Italian mothers born before 1948 from the transmission of Italian citizenship constitutes unconstitutional gender discrimination. The right existed from birth. It had simply not been recognized due to the unconstitutional 1912 law. In July 2025, the Italian Constitutional Court reaffirmed this principle with judgment number 142 of 2025. Citizenship by descent is acquired at birth and cannot be arbitrarily removed by the state. An important clarification: 1948 cases cannot be resolved administratively through the consulate. The only available route is judicial. A petition before an Italian civil court? This is not an obstacle. It is the only correct pathway for these cases. How do you know whether your case falls under the 1948 rule? It is straightforward. Your case is a 1948 case if three things are true simultaneously. First, the critical ancestor in your genealogical line is an Italian female citizen. Second, the child of that Italian woman, the next link in your genealogical chain, was born before January 1st, 1948. Third, the Italian woman did not naturalize as a citizen of a foreign country before the birth of that child. A practical example: your great-grandmother was born in Sicily, was an Italian citizen, never naturalized as an American, and had your grandfather in 1935 before 1948. Because your grandfather was born before 1948 to an Italian mother and a foreign father, he was not recognized as an Italian citizen under the 1912 law. This is a classic 1948 case. Now, the critical question: what changes for 1948 cases after Law 74/2025? There is a very important distinction here. If your petition was filed before March 27, 2025, full protection applies. Your case is assessed exclusively under the previous rules, with no restrictions whatsoever. If the petition is filed after March 27, 2025, the situation is more complex. Officially, the new restrictions of Law 74/2025 apply to judicial proceedings as well. However, many Italian courts have approved 1948 cases filed after March 27, 2025, ruling that the law does not apply on the grounds of the non-retroactivity principle. The jurisprudence is not yet unified, and this is precisely what the united sections of the Court of Cassation, the Sezioni Unite, are expected to clarify with a ruling anticipated in 2026. Let us look at how the judicial process works in practice for 1948 cases. The petition is filed before the competent Italian civil court. Since the 2021 reform, jurisdiction lies with the court of the district where the Italian ancestor was born, no longer exclusively with the Court of Rome. You do not need to travel to Italy. Our firm handles the entire process, from case assessment through to the filing of the petition, through our network of partners across Italy. The majority of 1948 cases are completed within 12 to 24 months from the filing of the petition. The success rate for well-documented cases remains exceptionally high. And an important practical advantage: Multiple family members who share the same Italian female ancestor can file a joint petition, significantly reducing the cost per person. 1948 cases are the most complex category of Italian citizenship, and they have become even more complex following the 2025 changes. They require a legal strategy that accounts for current jurisprudential developments, filing in the correct Italian court, and documentation that will withstand judicial scrutiny. Every case requires an individualized legal assessment before filing. If you believe your genealogical line passes through an Italian female ancestor, or if you are simply not sure, request a free assessment of your case. You do not need documents. You do not need certainty. You only need to know that you have an Italian female ancestor in your family line. Click the link in the description, complete the case assessment form, or contact our law firm by email or phone. Email info@italiandualcitizenshiplaw.com. Call 332-277-5023. Our law firm can review your situation and get back to you within 24 hours.